expert in 504. However, I'm lucky enough to work with Rosa Hirji, who is an expert in 504. But here's what I understand about 504 from my years in practice. 504 is an anti-discrimination statute. It really doesn't have anything to do with special ed per se. It basically says if you have a disability that's recognized under Section 504 under the ADA, you can't be discriminated against. That's all a 504 plan is. It doesn't entitle you to special services, and it doesn't entitle you to any real protection because there's not really any mechanism for enforcing 504 at the administrative level. So if you have a 504 issue, you're not going to really get anywhere unless you sue. So 504 is a kiss-off. The district is booting these people out of special ed, giving them a 504 plan, which we'll talk about a little bit, and essentially putting them in the position where they won't have any disciplinary protections. They're not going to have any special education and related services or any of the protections of IDEA. So, among the lawyers, we laugh about 504 plans for kids because we know that they're not really going to help the kid. But, let's say you're a regular ed student in a general ed classroom and you're perfectly fine, except for that you have a deformed right arm. I'm just making this up. 504 says the teacher can't say, well, your right arm is deformed, so you don't get to participate in the painting class with the other kids. It's a much more general anti-discrimination statute. It's intended to let people have access to, normal environments, notwithstanding their disabilities, and it can require reasonable accommodations. But I'd say for any person with a child with autism, the last thing you'd want would be to transition to a 504. Okay. I can't see how it would help. I could see how it would, potentially represent a source of problems and certainly a lack of appropriate services. And if the person is so well and so recovered as to no longer need IDEA services, I'd want to know what their reason is for thinking that. I'd want to know, okay, so there's not going to be any problems at transition when the student assumes his educational rights and becomes responsible for his own employment. You're telling me that, usually in situations where the child has really improved dramatically and or recovered, if that's the term you want to use, the parents are the one that are going to the IEP team and saying, look, we don't really want people to know what his diagnosis is, and we want him fully mainstreamed, and we don't want, special education services. But this is not the situation you're describing.
Okay, one of the arguments that I have heard for transitioning, especially in high school, to a 504 is that when they go to college, there is no IEP in college. It's only 504, and that for a lot of people, for a lot of parents and for a lot of students, it's a cold shower. That all of a sudden, you've left the high school process and you're in the 504 process and at college, and better to start to transition to that if the student is doing really well.
Well, but you see, it's a cold shower in any case, and we need to have a whole show where we talk about, oh my God, what happens when you graduate from high school?
Yeah.
The IEP has the student's accommodations in it. When the student gets to college, what you have to show for those accommodations to be implemented is that they were implemented for 6 months in high school, and then you're entitled to the accommodations. I don't know what else a 504 plan is going to get you at the college level. Theoretically, some protection from discrimination, but the thing about 504 is if you're being discriminated against, it's illegal whether you have a 504 plan or not.
Okay, boy.
It's a complicated area.
Yes, it really is.
But, our best hope for our kids is not going to be in a 504 plan.
Okay.